Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with another update on the Northern District of Illinois case. And Milton Brown, who is a co-defendant in this case, has filed a motion in limine, and I told you guys these motions are probably going to be popping out several a week leading up to this trial. And so we haven't heard much from Milton Brown in this case. You guys know he lives in Las Vegas, and he had been ill for some time since this arrest. Not sure what his health condition is at this point. But he has, along with his attorneys, has filed a motion in limine. And so we're going to go ahead and jump into this. It says Milton Brown's consolidated motions in limine. Defendant Milton Brown, by the Federal Defender Program and its attorney, Mary H. Judge, respectfully moves the court in limine for entry of orders excluding or admitting certain evidence and arguments as set forth below. Background. On February 13, 2020, the government filed a 13-count superseding indictment charging Robert Kelly, Darryl McDavid, and Milton Brown with a host of offenses. Count 6 of that indictment charges Mr. Brown with receiving tapes in violation of Section 18 U.S.C. Section 2252A 2 and B1. Specifically, the indictment alleges that from 2001 to 2007, Mr. Brown conspired with Kelly and McDavid, individual A, individual B, to receive 3 tapes according to counts 1 through 4. Those videos depict Rishona Lanfair. Count 5 alleges that Kelly employed Mr. Brown from approximately 1997 to approximately 2019. Importantly, count 6 is the only count under which Mr. Brown is charged. 1. This count should permit Mr. Brown to admit evidence of his own character. Federal Rule of Evidence 404A states that an accused may introduce evidence of a pertinent trait of his character. The word pertinent is read synonymous with relevant. United States v. Staggs, which is a case that was heard in the 7th Circuit in 1977. Consequently, the basic question is whether the character trait in question would make any fact of consequence to the determination of the case more or less probable than it would be without evidence of that trait. Such admissible character evidence may be proved by testimony about Mr. Brown's reputation or by testimony in the form of an opinion. And additionally, specific instances of Mr. Brown's character may be introduced if the character is an essential element of a charge, claim, or defense. Federal Rules of Evidence 405, evidence that Mr. Brown is a law-abiding person whom tend to make it less likely that he would knowingly break the law by retrieving a video. In Mickelson v. United States, a case heard in 1948, the Supreme Court stated that possession of characteristics, including being a law-abiding citizen, would seem incompatible with offering a bribe to a revenue agent, which was the crime charged. Mickelson, and also see United States v. Jobelt, First Circuit in 1974, character evidence is admissible to show a party's general renown for honesty and lawfulness. Ultimately, there is no indication of a general common law rule against the admissibility of evidence of law-abidingness as distinguished from good character generally, which, as noted, was usually held inadmissible. United States versus Angelina, which was a case from the First Circuit in 1982. So I guess June Brown said, y'all messing up his good name and reputation by involving him in this nonsense, and he's not having it. He's about to fight for his reputation. So because Milton Brown did not know the relevant materials at issue here constituting CP, i.e. that it, 1, depicted explicit conduct, and 2, that the depicted conduct involved Rashona, his trait of law-abidingness is relevant and admissible under Rule 404A. Okay, so 2, this court should preclude the government from eliciting testimony regarding certain other crimes, wrongs, and acts by Mr. Brown. A, the court should bar the government from eliciting testimony from Individual 4 and Individual 6 regarding the times Mr. Brown booked hotel rooms or otherwise made travel arrangements for them. Now, I think I kind of said I'm still going to hold on that I think number 4 is Tracy Sampson. And now that he's talking about travel arrangements, it kind of makes me really think it's her, because she was the intern at Epic Records, and I thought Epic Records was located in New York. I didn't think it was in Chicago, and so that would make sense that it was her, because he's saying about the flight arrangements, and maybe she had to fly from New York to Chicago. But then it seems like she lives in Chicago, because isn't she the one with the cupcake, the bakery or something business, cupcake business? Anyway, or maybe she traveled with him somewhere. I don't know, but she shouldn't have been traveling anywhere when you consider how old she was. So we're going to move on. So the government may seek to elicit testimony by her and the other person under Federal Rules of Evidence 404B2. Specifically, the government may seek to admit statements by witnesses, including her and the other person, that Mr. Brown reserved hotel rooms for them on behalf of Mr. Kelly, testifying before a grand jury. This individual might say, I talked about, or the individual stated in the grand jury testimony, I talked about a time when I went with my friend to pick up a hotel key room from Abe, who was at the front desk of Rob's record studio, Tracks. Before that happened, I had a conversation with Rob's assistant, Milton June Brown. June was the one who told me that Rob wanted me to get a hotel room and wait there for Rob. June wanted me to reserve the hotel room myself. I told him that I couldn't do that because I was 16. Appearing before the same grand jury, individual 6 stated, when we traveled and before I was over the age of 18, Rob had employees who would help arrange my flights and who would meet me at the hotel to give me keys to the hotel rooms. Often the people who helped with arranging flights and hotels were Milton June Brown and Junebug. I believe that June and Junebug knew that I was not 18 because I could not get my own hotel rooms. And then that's a transcript from 2019. And they had to do it for me. June met me at a hotel and gave me a room key when I was still not 18 at least 10 times. The probative value of those statements, if any, would presumably be to demonstrate knowledge under Rule 404B2, insofar as the statements would suggest Mr. Brown knew that the individuals were not 18 because they could not reserve hotel rooms on their own and needed Mr. Brown to do so for them. These statements should be barred under Rules 802 and 404B1. Generally, evidence of other acts is inadmissible. To prove a person's character in order to show that a particular occasion the person acted in accordance with the character, Federal Rules of Evidence 404b1. There is, however, an exception to that general rule where the evidence is admitted to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Federal Rule of Evidence 404b2. In determining whether prior bad acts evidence would be properly admitted under Rule 404b, courts previously considered whether 1. The evidence is directed towards establishing a matter in issue other than the defendant's propensity to commit the crime charged. 2. The evidence shows that the other act is similar enough and close enough in time to be relevant to the matter in issue. 3. The evidence sufficient to support a jury finding that the defendant committed the similar act. And 4. The probative value of the evidence is not substantially outweighed by the larger of unfair prejudice as required by Rule 403. United States Hicks is a case from the 7th Circuit in 2011. United States versus Harris is a case from the 2nd Circuit of 2014. And before we get to what these cases we're talking about, when they talk about that grand jury transcript, and that was from September 12, 2019, where this individual 6 stated that she assumed that June Brown knew. Well, you can't assume what anybody know, because June Brown was probably sitting there saying that your fast ass was out there going to a hotel, so you must be old enough to go to the hotel. And maybe he thought you couldn't book the room yourself because you didn't have any money to book the room yourself, and that you wanted Mr. Kelly to book the room, and so you couldn't go up there and book the room and use his credit card. I mean, June Brown probably had a credit card or had authorization to use the credit card that was being used to book the room. So how do you just assume that he knew how old you were? That's crazy. And why the government thinks that that is okay also. So the 7th Circuit jettisoned the above 4-part test, which some had to treat as an artificial checklist in favor of a more straightforward rules-based approach. Still, the Gomez court made sure to note that the 4 factors or steps of the old test, which touch on the principles of Rule 404. For instance, the court noted that step 2 of the test, which requires an inquiry into similarity and timing of the other act, is loosely connected to the basic principles of relevance found in Rules 401 and 402. At 854, and that's where it's notated in the document, expanding on that, the Gomez court restated the principle in positive terms as the extent to which a proffered other crime, wrong, or act is close in time and similar to the conduct at issue in the case may have a hearing on its relevance. Okay, 1. The alleged hotel reservations and travel arrangements made by Mr. Brown are irrelevant to the allegations in count 6. First, hotel reservations and travel arrangements for individuals 4 and 6 are irrelevant to the charge Mr. Brown is facing and therefore should be inadmissible. As it concerns Mr. Brown, this case involves only one count, count 6, and only one individual, Rishona. In that count, Mr. Brown is accused of receiving CP, making travel arrangements and reserving hotel rooms on behalf of an employer are actions that are not at all similar to receiving a video. Additionally, those prior acts occurred years before the conduct alleged in count 6. Simply put, Mr. Brown's knowledge of other individuals' minority statuses, referring to 4 and 6, is not relevant to whether Mr. Brown knew the minority or the individual depicted in the tape at issue, which is count 6. 2. The other crimes, wrongs, or acts here are improper propensity evidence. Second, because Mr. Brown is charged only in count 6, which involves Rishona's minority status alone, the prior bad acts evidence discussed here would, even if relevant, be improper propensity evidence under Rule 404b1. The value of these statements to the government may be that since Mr. Brown allegedly aided Kelly's exploitation or knew that Kelly had relations with these individuals, the jury might be more inclined to believe that Mr. Brown would have been more likely to have aided Kelly in obtaining the videotapes at issue in count 6. Alternatively, these prior acts would presumably be offered to show an increased likelihood that Mr. Brown should have known that the tapes at issue in count 6 involved the individual. These 404b2 purposes, however, are not enough. In Gomez, the Seventh Circuit clarified the problem of multiple prior bad act evidence purposes, i.e. cases where the evidence involves both improper propensity use and ostensibly proper Rule 404b2 uses as follows. We have cautioned that it's not enough for the proponent of the other act evidence simply to point to a purpose in the permitted list and assert that the other act evidence is relevant to it. Rule 404b is not just concerned with the ultimate conclusion, but also with the chain of reasoning that supports the non-propensity purpose for admitting the evidence. In other words, the rule allows the use of other act evidence only when its admission is supported by some propensity-free chain of reasoning. This is not to say that other act evidence must be excluded whenever a propensity inference can be drawn. Rather, Rule 404b includes the evidence of its relevance to another purpose is established only through the forbidden propensity inference. A bunch of legal jargon. I don't know why they can't just get to the point. So basically they're saying sometimes you can use the evidence and sometimes you can't. So identifying the underlying principle, the Gomez court explained, the principle that emerges from these recent cases is that district court should not just ask whether the proposed other act evidence is relevant to a non-propensity purpose, but how exactly the evidence is relevant to the purpose, or more specifically, how the evidence is relevant without relying on a propensity inference. You know, it sounds to me like they arrested the June Brown guy, hoping to get him to flip and testify against Mr. Kelly. That's what this sounds like to me, that if they put enough fear in him that he would have turned on Mr. Kelly, and so far that has not worked in their favor. So then it goes on to say, looking at the chain of reasoning here, we see that both of the both of the above hypothetical Rule 404b2 uses suffer from and depend on propensity inferences. Indeed, the statements necessarily involve propensity inference of the worst kind. First, they depend on an inference that, when allegedly working with Mr. Kelly to retrieve the tapes, Mr. Brown acted in accordance with his prior unrelated conduct. Further, they also depend on 3 additional, even more troubling inferences unrelated to Mr. Brown's own character. 1, that Kelly, when producing the tapes, acted in accordance with his prior conduct. 2, given Kelly's prior conduct, the person depicted on the tape was likely Rishona as well. 3, was likely Rishona, then should be a comma here, as well as number 3, that Kelly would have been more likely to ask Brown to retrieve the videotapes because Kelly had employed Mr. Brown to facilitate his prior unrelated conduct involving certain individuals. Thus, these statements would violate the principle articulated in Gomez. In sum, the government should be barred from eliciting such testimony. First, the other act's evidence constitutes inadmissible hearsay. Second, the other acts are too dissimilar and distant in time to be relevant to the allegations in count 6. Third, the other act's evidence constitutes impermissible propensity evidence because the chain of reasoning necessarily includes propensity references. So B, this court should bar the government from eliciting testimony from individuals D and B regarding Mr. Brown's role in arranging an abortion for one or more of Kelly's alleged partners. Now, what Lisa Van Allen know about somebody having an abortion? And then is B Yule? Did we decide that B is Yule Brown and C is Damon Pryor? So the government may seek to elicit testimony from Lisa Van Allen regarding the role that Mr. Brown may have played in her abortion. Okay, so she had the abortion. Specifically, the government may elicit testimony from Lisa Van Allen that Kelly paid for an abortion and that Mr. Brown, acting as Kelly's assistant, made the abortion appointment, drove Lisa Van Allen to the appointment, and posed as Lisa Van Allen's uncle when they filled out the paperwork for the procedure. Additionally, the government may seek to elicit speculative testimony from individual B, who I'm just going to say is Yule Brown. Mr. Brown and others arranged abortions for other people on Kelly's behalf, and that Mr. Brown and others had asked him about abortion laws. The court should bar the government from introducing these prior acts. As with motion in limine number 2A, the prior acts here, i.e. Mr. Brown's alleged conduct in arranging abortions, are irrelevant. First, Lisa Van Allen was either 19 or 20 years old at the time and was therefore not a minor. Second, Lisa Van Allen's minority status is not at issue in this case as it concerns Mr. Brown. Third, there is no indication that Rishona is one of the individuals who were rumored to have received an abortion arranged by Mr. Brown. Fourth, these abortion allegations are not similar or close enough in time to be relevant to the allegations in count 6. Further, should this court determine that the testimony is relevant, the court should exclude it as unduly prejudicial under Federal Rule of Evidence 403. Under Rule 403, the court may exclude relevant evidence if it is probative value is substantially outweighed by a danger of unfair prejudice, confusing the jury, or wasting time. Federal Rule of Evidence 403. Evidence is unduly prejudicial if it creates a genuine risk that the emotions of the jury may be excited to irrational behavior, and the risk is disproportionate to the probative value of the offered evidence. United States versus Laurie, a case heard in the 7th Circuit in 2011, testimony that Mr. Brown arranged abortions for individuals is obviously likely to elicit a strong negative emotional response from jurors. Additionally, because those rumored and alleged abortions involve people other than Rishona, and because the ages of those people, including individuals and adults, varied significantly between the ages of 16 to 20 years old, there is substantial risk that the testimony would confuse jurors. What little probative value the evidence may have is substantially outweighed by the risk of unduly prejudicing and confusing jurors. Accordingly, Mr. Brown moves to bar the government from eliciting such testimony. And rightfully so, because if Lisa Van Allen, who we know from the Tony Rivera lady, who is the trafficking advocate, who says that she used to run with Lisa Van Allen when she was caught up in this system with this guy that she was dating. And you guys, Tony Rivera, I first heard about her when she was on the Breakfast Club, and it was Charlemagne the God who threw Lisa Van Allen's name out there and said, now you know Lisa Van Allen, right, who used to date R. Kelly. And she said, yeah, me and Lisa used to run in the same circles. And so basically Tony Rivera was trafficked by this guy. She had went to Freaknik in Atlanta, met this guy, got called up, found out he was a pimp, went back home. He went back and went to her home state and got her and brought her back to Atlanta. And she talked about how they would go into churches and stuff like that and be preying on people to get them into the trafficking game for this guy, turning these people into prostitutes. And that's how she met Lisa Van Allen. And so then Lisa Van Allen somehow meets R. Kelly, and he invites her. He basically saved Lisa Van Allen. Let's just call it what it is. He got her out of that lifestyle and took her to Chicago and provided her this lifestyle. And she was just ungrateful and selfish. Okay. So the fact that Lisa Van Allen had an abortion when she was an adult and capable of going to the abortion clinic herself and scheduling an abortion has nothing to do with this case. And then so this is what's crazy to me about these people. So you mean to tell me that you're sleeping with R. Kelly, who was a big sensation at the time, and you get pregnant from him and you're going to go have an abortion? Wouldn't your meal ticket be to have that baby and get that money the legal way? Like, wouldn't that make more sense? And keep in mind, all of this is going on, like all these charges in the Northern District of Illinois case were while he was married to Drea. He met Drea in 1996, and the first case is 1996. So while Drea was having her 3 children, all this was spanning over the 6 years that Drea was building her family, having her kids every other year, right, is when all these cases take place. So you mean to tell me that this man was making music, touring the country, caring for his new wife, his newborn babies, and still had time for all this nonsense with these fools? But all this was going on at the same time that he had just gotten married, was starting his family, at the height of his career, all of this, like his career was taking off at this time. And they want us to believe that all this was going on. And on top of that, they want us to believe that somebody got pregnant, that multiple people got pregnant from him during this time period and went and had abortions instead of having those babies and getting a grip, making their money off of having a baby from this man who was a rising superstar at the time. Like, who do they think we are? Do they really think we're that dumb? Anyway, moving on. And then, like this attorney says, what do these abortions have to do with the allegations y'all make? And can you prove that the abortions took place and that Mr. Kelly paid for the abortions? I don't even understand why a 20-year-old would need somebody to go to the abortion clinic with her and pretend to be her uncle. That makes no sense. But anyway, I guess they'll reveal it to us at the trial. So C, the court should preclude the government from eliciting testimony from Yul Brown. I'm just going with individual B as Yul Brown regarding Mr. Brown's role in inviting concert attendees backstage for Kelly. The government may seek to elicit testimony from Yul Brown regarding the role Mr. Brown may have played in inviting individual concert attendees to meet Kelly. Specifically, the government may prompt Yul Brown to testify that Kelly would identify people ranging in age from 16 to 20 years old in the audience and instruct his employees, including Mr. Brown, to invite them backstage. Now, you're a performer on stage looking out into the audience where the lights are off, strobe lights are running, smoke is up in the air, because we know how these concerts are, right? And you said, hey, that person is 16, go get them. Excuse me, how do you know how old somebody is sitting in the audience? among a sea of hundreds and thousands of other people. Like, that makes absolutely no sense. For the reasons discussed in motion number 2A, the court should bar the government from eliciting testimony as to Mr. Brown's role in inviting concert attendees backstage to meet Kelly. Once more, these prior acts are irrelevant to the charge in count 6. There is no indication that Rashona was one of the attendees who Mr. Brown invited to meet in this way. Indeed, Rashona did not meet Kelly at a concert. Moreover, Mr. Brown played no role whatsoever in the introduction of Rashona to Kelly. Also, there is no indication that Mr. Brown witnessed Kelly engage in activity with any of the attendees that he invited backstage. Again, the conduct is not similar enough to be relevant to the allegations in count 6. Furthermore, even if this count finds that it is relevant, it should preclude testimony as to the acts under Rule I'm sorry, I got a text message from my daughter about somebody got arrested. Okay, let me get back to this. It should preclude testimony as to the acts under Rule 403, as with the abortion discussed above. The alleged conduct here would unduly prejudice and confuse the jurors. 3. The court should bar the government from eliciting expert testimony from unqualified witnesses. The government may seek to have law enforcement witnesses provide opinion testimony about videos generally, including typical offender behavior. This testimony would be based on special knowledge and expertise outside that which the average layperson possesses. So it would be inadmissible as lay testimony under Federal Rules of Evidence 701. See United States versus York, which was heard in the 7th Circuit in 2009. United States versus Will, which was heard in the 7th Circuit in 2021. Expert testimony generally involves technical concepts beyond ordinary understanding. As such, before being permitted to elicit such testimony, the government should be required to qualify that witness as an expert. See Federal Rules of Evidence 702. If the government does not seek to qualify a witness as an expert, that witness should be limited to giving fact testimony and only those opinions or references that are not based on specialized knowledge, such as the witness participation in the investigation and statements made by others, if not precluded by the hearsay rules. The government may seek to avoid the expert testimony requirements by characterizing these witnesses as summary witnesses or claiming they are merely summarizing evidence. But merely claiming that witnesses are summary witnesses does nothing to alter the application of Rule 701 and 702, because such law enforcement witness testimony should be based on knowledge about CP, about which lay people are uninformed. Rule 702 would be triggered. See United States versus Weir, 7th Circuit 2021. The government should be allowed to circumvent the rules for expert should not be allowed to circumvent the rules for expert testimony and take away this court's important gatekeeping role merely by characterizing these witnesses as summary witnesses, particularly whereas here Mr. Brown is making this objection well in advance of the testimony. So basically they're going to have the police come in there and try to give expert testimony about these videos and what Mr. Kelly was thinking and what these individuals were thinking when they agreed to be in the videos. So 4, this court should preclude government witnesses from providing summaries or statements from interviewed witnesses for non-testifying individuals. The Sixth Amendment provides a criminal defendant with the right to be confronted with the witness against him. U.S. Constitution Amendment 6. This bedrock procedural guarantee protects against convictions based on out-of-court accusations that the defendant cannot test in the crucible of cross-examination. Crawford versus Washington, a case heard in 2004, to testify. I'm getting tie-tongue, y'all. To satisfy the confrontation clause, testimonial statements of witnesses absent from trial may be admitted only where the declarant is unavailable and only where the defendant has had a prior opportunity to cross-examine. Despite the confrontation clause guarantee, there are some limited exceptions, as the Seventh Circuit noted. We have explained that such out-of-court statements are admissible as non-hearsay when offered to make a defendant's recorded statements intelligible for the jury, that is, for context, or when brief and essential to bridge gaps in the trial testimony that might significantly confuse or mislead jurors. United States versus Walker, 7th Circuit in 2012, cleaned up. Still in that very decision, the 7th Circuit immediately cautioned that these limited non-hearsay uses do not open the door for law enforcement officers to narrate the course of their investigations and thus spread before juries damning information that is not subject to cross-examination. Having repeated that warning, the 7th Circuit then offered the following criticism of the government's use of out-of-court statements. The government repeatedly hides behind its asserted needs to provide context and relate the course of the investigation. These euphemistic descriptions cannot disguise a ploy to pin the two guns on defendant while avoiding the risk of putting the non-testifying informant on the stand. So the government got some informants that they want to tell their story, but they don't want to put those people on the stand. Thus, the 7th Circuit has made clear, I wonder if it's Michael Avenatti that they're talking about, because they definitely can't put him on the stand after he done been convicted and getting ready to plead guilty in another case. So clear that the exception to the confrontation clause must be limited if it is not eviscerates the constitutional right to confront and cross-examine one's accusers. United States versus Silva, 7th Circuit, 2004. And you guys, you know that's what they did in the in the Eastern District of New York case, where they pretended like the witness, and I believe the witness was Lisa Van Allen, even though y'all think it's the Adina, what's her name? Adina Prada. The girl that y'all think is the person from Minnesota. Everybody thinks that's who had the so-called panic attack in New York when she was supposed to testify. But I believe it was Lisa Van Allen, and they didn't want to put Lisa Van Allen on that stage, on that witness stand, because they knew she was a part of this case, and so they faked the panic attack so that she didn't have to testify. But anyway, additionally, other circuits have taken a similarly strong stance. Oh, and the point I was making was that they did that so that they were able to show those videos without the people that were actually in the videos getting on the witness stand and testifying, because we know that some of them, like Dominique said, I'm not going up there on that witness stand. I don't care what you say. And then Lisa Van Allen, gotta hold the toe for I'm sorry, y'all, my daughter the county just busted Target for selling fertilizer. Okay, we was talking about, I don't know where you guys live, but where I live, you can't buy fertilizer for your yard between June 1st and September 30th or September 15th, something like that. But stores in other counties will sell fertilizer. So basically I could go to the next county and buy the fertilizer and bring it back home. But now they have these sting operations where you have to ask the people for a driver's license that shows their address before you can sell them the fertilizer. So I guess Target was selling fertilizer and just got busted. Okay, so she just keep on texting me, but I'm going to try and move on here. Okay. So additionally, other circuits have taken similarly strong stance. Consider, for example, the Fifth Circuit's recent warning against the use of out-of-court statements against criminal defendants in United States versus Hammond out of the Fifth Circuit in 2022. So that happened just recently. In that case, Officer Stanley offered testimony to explain how the Drug Enforcement Administration became interested in Hammond. When testifying, he offered the testimonial hearsay of non-testifying witnesses, a confidential source, an unknown declarant, and a non-testifying officer. The confidential source, Stanley testified, told him that Hammond was moving multiple ounces of meth. The unknown declarant, Stanley testified, told other law enforcement agencies that Hammond was selling narcotics. Then Stanley proceeded to recount the controlled purchase that justified the search warrant and veered off course again when he described a controlled buy that was witnessed by Stanley but by another officer who never testified. When evaluating Hammond's confrontation clause challenge, the Fifth Circuit outlined in its query as follows. We asked 3 questions to determine whether admitted evidence violated the confrontation clause. First, did the evidence introduce a testimonial statement by a non-testifying witness? Second, was any such statement offered to prove the truth of the matter asserted? Third, was the non-testifying witness available to testify, or was the defendant deprived of the opportunity to cross-examine him? If the answer to each of these questions is yes, the confrontation clause was violated. Good point, because they sure was letting evidence in New York and nobody was provided to verify that the information was true, and the defendant did not get the opportunity to cross-examine. We just had to take the government's word that this is what happened. So internal citations omitted. Applying the test, the Fifth Circuit found that the government had violated the confrontation clause because it was testimonial. The primary purpose was to establish events relevant to criminal prosecution, offered for the truth of the matter asserted. The evidence blatantly linked the defendant to the crime, and the non-testifying witnesses were not available, and the defendant did not get a chance to cross-examine them. Turning to the decision's reasoning, the Fifth Circuit's discussion of the confidential sources statement is beneficial, but for our purposes, the most relevant analysis is that of Stanley's testimony regarding the controlled buy. Accordingly, the following excerpt provides the Fifth Circuit's reasoning as to that testimony. It's true that if Stanley had provided only his own observations, there would be no confrontation clause problem, but Stanley was unequivocal. He didn't personally have eyes on the hotel where the controlled purchase happened. Instead, he listened by radio to another officer describing what was happening and debriefed the source after the sale. A man who listened to a Dodgers game on the radio and spoke to a friend who attended the game doesn't have personal knowledge of the game's winner. Then Scully and the friend do. That man couldn't testify about the game without relying on the accuracy of third parties' observations, and neither should Stanley testify about the controlled purchase without doing the same. Makes sense to me. So anyway, lastly, the Fifth Circuit admonished the government for not heeding its warnings against backdooring highly inculpatory hearsay via and explaining the investigation rationale, and failing to be circumspect and limited in its use of such out-of-court statements. With the authority in mind, Mr. Brown asked the court to exclude from trial any reference to the statements of other non-testifying individuals as violative of the confrontation clause. Additionally, under Rule 802, Mr. Brown asked the court to exclude any hearsay statements not subject to Rule 801 exceptions. 5. This court should preclude the government from making golden rule arguments with regard to the jury and the defendants. The government may ask the jury to put themselves in Mr. Brown's shoes and ask them to consider what they would have done if they were him. Any such arguments, regardless of the evidentiary circumstances in which the government might make them, are impermissible because they are golden rule arguments. Commenting on that impropriety, the Seventh Circuit has noted that a golden rule appeal in which the jury is asked to put itself in the defendant's position is universally recognized as improper because it encourages the jury to depart from neutrality and to decide the case on the basis of personal interest and bias rather than on the evidence. United States versus Roman, from a case in the Seventh Circuit in 2007. United States versus Teslin, 7th Circuit, 1989. Simply put, the government should not ask the jurors to put themselves in defendant's position. United States versus Teslin, 7th Circuit, 1989. Conclusion. For the above stated reason, Mr. Brown respectfully requests that the court grant his motions in limine. Mr. Brown also respectfully requests that the court allow him to submit additional motions in limine in response to subsequent discovery productions, notice as to Rule 702 or 404 evidence, and the filing of witness and exhibit lists. So listen, y'all was talking about June Brown attorney when they had that hearing a couple of weeks ago, saying that she was slow, but Mary Judge seemed to be on her game, and she's actually a federal defender. And people talk about federal defenders like I would never have a federal defender or public defender because they work for the government. No, public defenders are people who are trying to get some experience so that they can go and start their own law practice and become a Jennifer Bongine. And you guys should watch the show All Rise that comes on the OWN network. It was on ABC, but now it's moved over to OWN. And basically it's about a court system. The main character is a black woman who's a judge, but it really focuses on the court system and the public defender's office and how the public defender's office works with private attorneys and bringing these cases together and the stuff that goes on behind the scenes and that type of thing. And it's a really good show. And so this Mary Judge lady is a public defender for June Brown, but she seems to be on her game. So that's it for me. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.